War and conflict has been the way to settle disputes since the beginning. But as modern warfare progressed, the international community has established laws that regulate and govern the states during wartime as a way to limit the brutality of war. As part of international law of war deals with the commencement, demeanor, and termination of warfare. It particularly aims to limit the suffering caused to combatants, and more especially to those who may be described as the victims of war. War is often associated and viewed with acts of violence, in which only states can participate. However, war has grown to become more complex. Today, modern international law recognizes that wars are defined as contention by force that can involve with or between non-state entities, with or without formal declarations, and with or without the element of violence. It is not only an act, but also a state or condition.
The efforts to apply rules to war is ancient. A war control system emerged during the early medieval period, known as the just war tradition. This doctrine emerged as a consequence of the Christianization of the Roman Empire and the ensuing abandonment by Christians of pacifism. With the rise of European nation-states, emphasis in legal doctrine moved from the application of force to suppress wrongdoers to a concern to maintain order by peaceful means. Grotius tried to exclude ideological considerations as the basis of a just war. But with positivism and the establishment of the European balance of power system, emphasis on the concept of just war declined. European leaders fought their wars purely for state interests without concern for moral questions. From time to time, war aims are still stated in moral terms such as the goal of protecting democracy in the First and Second World Wars. In the present time, most scholars agree that to be considered just, a war must meet several jus ad bellum requirements. Jus ad bellum is the title given to the branch of law that defines the legitimate reasons a state may engage in war and focuses on certain criteria that render a war just. What you're seeing in your screen are the most important conditions. The principal modern legal source of jus ad bellum can be derived from Article 2, Paragraph 4 and Article 51 of the UN Charter. This modern legal source will be discussed further later on.
What are the rules of war and why do they matter? The rules of war, or the international humanitarian law as it is known formally, are a set of international rules that set out what can and cannot be done during an armed conflict. The main purpose of international humanitarian law, or IHL, is to maintain some humanity in armed conflicts, saving lives and reducing suffering. To do that, IHL regulates how wars are fought and balancing two aspects, such as weakening the enemy and limiting suffering. The rules of war are universal. The Geneva Conventions, which are the core element of IHL, have been ratified by all 196 states, and very few international treaties have this level of support. Everyone fighting a war needs to respect IHL, both governmental forces and non-state armed groups. War crimes are documented and investigated by the states in international courts. There is a need to balance military necessity and humanitarian consideration, and for you to be able to win in a war, you need to weaken the military forces of the enemy and render their dead. But that employment would be therefore contrary to the laws of humanity. That's why the International Commission of the Red Cross published 3 statements which sum up the basic rules governing armed conflicts. First is the soldier's rule, second is the fundamental rules of international humanitarian law, and lastly the non-international armed conflict.
Sanctions of the laws of war. In international law, a sanction is an action done by one or more states toward another state in order to make the latter comply and cooperate in accordance with its legal obligations. Unlike in domestic law, that a sanction is a punishment given when a citizen broke a law in form of imprisonment or any legal action. In international humanitarian law, sanctions may be applied not just to states, but also to the following. 1. To civilian internees and prisoners of war responsible for breaches of laws, regulations, and general orders to which they are subject. 2. To persons who have committed war crimes or other breaches of international humanitarian law. And 3. To commanders responsible for failure to act. The following are the different topics in relation on sanction of the laws of war. First is disciplinary sanctions, which are applied to members of military groups participating in a war who have violated a rule within the group. Next is breach. Breach is a punishable act, although not a grave breach, but still an issue to international humanitarian law. Whether the breach is established because of a direct violation of a rule or because of the failure to fulfill an obligation, there will be sanctions applied either to state or a group or an individual having international legal personality. Next is state responsibility. Under general international law, the responsibility of a state is engaged if the actions of its agents or actions otherwise attributable to it constitute internationally wrongful acts or in violation of its international obligations. In international humanitarian law, Common Article 1 to 4 Geneva Conventions demands that every state, whether a party to an armed conflict or not, ensure respect for the laws of war. Hence, if a violation occurs, not only the injured state, but every state may and must take measures to restore respect for international humanitarian law. Lastly, individual criminal responsibility. Besides state responsibility for violations of international law, individuals may be held criminally responsible and accountable for international crimes such as war crimes, crimes against humanity, and genocide. This principle can be dated back to the Labor Code and is a long-standing rule of the customary international law. Now,
let's talk about termination of war. Under termination of war, we have simple cessation of hostilities, negotiated treaty of peace, and defeat of one of the belligerents. Under simple cessation of hostilities, war may end in this manner simply because the belligerents are no longer willing to continue fighting. When the war ends in this way, property or territory in the possession of the respective belligerents upon the termination of the hostilities are retained by them under the principle of uti possidetis or as you possess. Next one is negotiated treaty of peace. In here, this is a treaty concluded by the belligerents when neither is able to effect to decisive victory over the other. And last one, we have defeat of one of belligerents. The defeated belligerent may surrender either conditionally or unconditionally in the former case. A treaty of peace is concluded which makes provision for the conditions specified in the surrender.
the outlay of war. The outlay of war is the pleasing of war as a means of national policy outside the line of law. It has been believed that war has been regarded in certain instances as the last resort of a state to obtain what it believes to be its lawful object. Unlike in domestic law, wherein an individual's action is restricted by law and police force, a state under the international law can use or resort to war as a means of attaining or protecting its national interests. During the 30 Years' War, Hugo Grotius published his monumental Treatise de Jure Belli Ac Pacis, in which he said, "Throughout the Christian world, I observed a lack of restraint in relation to war, such as even barbarous races should be ashamed of. I observed that men rush to arms for slight causes or no causes at all, and that when arms have once been taken up, there is no longer any respect for law, divine, or human. It is as if, in accordance with the general decree, frenzy had openly been let loose for the committing of crimes, thus commencing the growth in international law of a set of rules in governing the conduct of wars, with the existence of arbitration and conciliation treaties, such as in the Covenant of League of Nations before, which paved the way for many intergovernmental organizations in order to effect a certain humanization of the practice of war and to lessen the number and kind of circumstances in which war could legitimately be resorted to."
The failure of the United States to join the League of Nations due to opposition in its Congress, French Foreign Minister Aristide Briand first suggested a bilateral non-aggression pact against a possible resurgence of German aggression after its loss in the First World War. Influenced by the American outlawry of war movement, the U.S. Secretary of State Frank Michaella proposed that the pact be converted into a general multilateral treaty, in which signatory states pledged not to use war to resolve disputes or conflicts. This will be known as the Calabrian Pact of 1928, also known as the Pact of Paris. The outlawry of war movement has paved the way for one of the most extraordinary manifestations of universal desire for peace that has ever been witnessed in the history of the world. Despite its promising provisions, the Calabrian Pact was rendered irrelevant and ineffective after the treaty's failure to establish means of enforcement and halting the aggression that led to the World War II. However, despite such criticisms, The pact became one of the legal bases for the prosecution of the perpetrators of the World War II and provided a new attitude towards third-party intervention on disputes and the legal restrictions on the use of force in international law.
The right of existence and self-defense, so it is made if there's a presence of an armed attack. The right may be restored only upon clear show of grave and actual danger to the security of the state. So they drafted the Declaration of Rights and Duties of the State that every state has the right of individual or collective self-defense, which means all UN member countries use military force to defend its member or itself. They authorize the regional agreement to help maintain peace and security, including disputes, through these agencies. So the example of this is the Organization of American States.
Next is we have collective security. Collective security is a system that guarantees the security of each state of the world against any war or aggression which may be committed by any state or against any other state. So it can be seen as a plan for maintaining peace through an organization of sovereign states whose members agreed to defend each other from the attack. So the concept of this is best seen as a security for individual nations by collective means, that is by the membership in an international organization made up of all or most states of the world pledged to defend each other from the attack.
In international law, there is a general principle that recognizes the autonomy of individual states and their right to freedom from coercion and to the integrity of their territory. Article 2, Paragraph 4 of the United Nations Charter declares that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations. This provision is now regarded as a principle of customary international law and as such is binding upon all states in the world community. The word force is used rather than war because the word war is a technical term which does not include some uses of force. The reference to force rather than war is beneficial and thus covers situations in which violence is employed which fall short of the technical requirements of the state of war. It is to be noted that Article 2, Paragraph 4 also covers threats of force. This issue was addressed by the International Court in its advisory opinion to the General Assembly on the legality of the threat or use of nuclear weapons. The court stated that a signaled intention to use force if certain events occur could constitute a threat under Article 2, Paragraph 4, where the envisaged use of force would in itself be unlawful. The provision governing the resort to force internationally do not affect the right of a state to take measures to maintain order within its jurisdiction.
Peaceful settlement of international disputes is a fundamental principle of international law of a peremptory character. It is formulated as such in the UN Charter, Article 2, Paragraph 3, and developed in UNGA Resolution 2625 on principles of international law concerning friendly relations and cooperation among states. Classification of disputes. Legal dispute, it involves justiciable rights based on law of fact. Example of this is conflict on the interpretation of a treaty on the ascertainment of the boundary lines adjacent states. Next one is political disputes, one that cannot be decided by an international arbitral or judicial tribunal under the rules of international law. In a case in one state, in the exercise of its sovereign states, enacts immigration laws discriminating against the nationals of another state over the latter's protest. States themselves bear primary responsibility for the pacific settlement of disputes, while the Charter enumerates institutional arrangements to facilitate the pursuit of this principle. Under settlement, disputes are supposed to be settled conformably to one of the basic principles of the UN, which is by peaceful means in such manner that international peace and security and justice are not endangered. The amicable methods of settling disputes are negotiation, security, good offices, mediation, conciliation, and arbitration. Under negotiation, it is generally the first step taken in the settlement of international disputes. It is nothing more than the decision by the parties themselves of their respective claims and counterclaims with a view to their just and orderly adjustment. While inquiry, it is an investigation of the points in question on the theory that their elucidation will contribute to the solution of the problem. As most disputes are caused by misunderstandings of certain factual situations, their clarification by an impartial and conscientious body can limit, if not entirely remove, the areas of disagreement. While good offices, it is the method by which a third party attempts to bring the disputing parties together in order that they may be able to discuss the issues in contention. This is usually employed when the protagonists are no longer on speaking terms, that is, when they have severed diplomatic relations or have actually commenced hostilities. While in mediation, it differs from good offices in that the mediator does not merely provide the opportunity for the states to negotiate but also actively participate in the discussions in order to reconcile their conflicting claims and appease their feelings of resentment. And for conciliation, it involves active participation of a third party in the attempt of the disputants to settle their conflict. And lastly, we have here the arbitration. It is a process by which the solution of a dispute is entrusted to an impartial tribunal, usually created by the parties themselves under a charter known as the compromise, which also provides for the composition of the body and its rules of proceedings, delineates the issues to be decided, and sometimes specifies beforehand the law to be applied in the decision.